Hi, I'm Immigration Attorney Heather Poole. Today I will be talking about the new proposed Provisional Waiver program for the unlawful presence waivers, what it could do for you and your spouse, who qualifies for it, and the reality of it actually becoming available. Remember, it is extremely important to speak with an immigration attorney about your case to determine what issues you could face that could result in a denial or even a removal from the United States. For more information about me, stay tuned until the end of the video to learn more about my extensive experience in this area. First, we have to cover the basics so you know what I'm talking about. What is the 3 and 10-year bar? The 1996 Illegal Immigration Reform and Responsibility Act, what we immigration attorneys refer to as IRA, created the 3-year, 10-year, and permanent bars to admission to the U.S. for violation of immigration status. These bars apply widely and affect immigrants who have family in the U.S., who have worked and even paid taxes, and in many cases are otherwise eligible for permanent residency status. The 3-year bar to re-entry into the U.S. The 3-year bar applies to individuals who have been unlawfully present in the United States for a continuous period of more than 180 days, and then when they voluntarily depart the United States, the bar is triggered. Even if the consular process they are departing for is to obtain an immigrant visa. Yes, this may apply even if you are married to a U.S. citizen. The 10-year bar to re-entry into the United States applies to individuals who have been unlawfully present in the United States without a visa, who have been here illegally, who have entered illegally, and have been here for more than a year. Unlawful presence begins to accrue when the period of authorized stay expires or after an entry to the U.S. without inspection, which is basically an illegal entry. The waiver option. If the immigrant is married to a U.S. citizen or lawful permanent resident or has a U.S. citizen or permanent resident parent, a waiver may be available for the 3 or 10-year bars, but not for the permanent bar. To qualify for this waiver, which if approved allows the immigrant to lawfully re-enter with the immigrant visa and not wait outside the U.S. for those 3 or 10-year periods, the immigrant must prove that his or her U.S. citizen or permanent resident spouse or parent will suffer extreme hardship if the waiver is not approved. Now let's talk about the new provisional waiver proposal. The recent announcement from USCIS of its intent to propose a new rule regarding the processing of unlawful presence waivers has sparked a lot of questions. This issue is all over the media since it was announced, and many are confused. USCIS has announced a proposal to create a new rule allowing for those who are having a consular process and are subject to the 3 or 10-year bars for unlawful presence to file their waivers with USCIS in the United States before attending their consulate interview. This would potentially eliminate long separation periods, especially in Ciudad Juarez, Mexico, between filing of the waiver and a final decision on the waiver, at which point only with an approval can the immigrant re-enter the United States. But there are important things to keep in mind about this proposal that we know so far. First, the provision is not in effect yet. We have no idea how long the rule will take to be implemented, although it is a positive step in that direction. According to the January 2012 teleconference with USCIS, the agency plans to introduce the final rule by the end of the year and the draft rule by spring 2012. No cases can be submitted under the provisional waiver process at this time, so don't send anything to CIS. Second, the provision may not go into effect at all, depending on the upcoming results of the November 2012 elections. The Department of Homeland Security is under the purview of President Obama, who has promoted more efficient, humane measures be taken in the immigration system, and the current proposal reflects and directly references this commitment. However, if President Obama is not re-elected to the presidency, this proposal may never happen, as a new president can direct DHS to stop all plans for the new policy. Currently, all Republican candidates for the presidency are more focused on anti-immigration enforcement measures, so the likelihood that this proposal would actually be enacted if a Republican president is elected are slim. Since this is a potential policy shift, the President does not need congressional consent to issue an executive order that agencies fall in line to follow. Remember, this does not change the law on unlawful presence waivers, only a policy. Third, If this proposed policy does eventually become effective, it will only apply to those married to U.S. citizens or have U.S. citizen parents as qualifying relatives for the waiver. It does not apply to those with lawful permanent resident spouses or lawful permanent resident parents for purposes of the qualifying relative for the waiver. Those people with permanent resident spouses or permanent resident parents that they're using to qualify for the waiver have to apply for the waiver abroad. They don't qualify under this new provision. It applies to those under the age of 21 who have U.S. citizen parents, which are considered immediate relatives. An immigrant parent who is being sponsored by their U.S. citizen child over the age of 21, but who has either a qualifying U.S. citizen parent of their own, which would be the petitioner's grandparent, or a U.S. citizen wife of the parent for qualifying relative for purposes of the waiver, will qualify under this new provisional program. You can see how complicated and narrow this can get. Those married to lawful permanent residents or qualifying for the waiver through LPR parents do not qualify for this special provision. These individuals would still have to consular process first, have the consulate conclude that unlawful presence exists, and then file the waiver. Fourth, the proposed policy only applies to 3- and 10-year bar waivers. If the immigrant has any other ground of inadmissibility, such as misrepresentation, crimes, the immigrant must process all the waivers, including the unlawful presence waiver, by traveling abroad for the immigrant visa interview under the current system. Fifth, under this proposal, if the waiver is approved in the U.S., the immigrant will still have to travel to the consulate abroad for their immigrant visa interview. But there will be no need to stick around to file the waiver, as it will already be considered in effect the minute the immigrant departs the U.S., if it has already been approved by CIS in the United States. Sixth, if you are already abroad and waiting to file your waiver or waiting for your waiver to be decided now, currently this provision does not apply to you. So what does this mean for those of you who may be impacted? You will have to weigh the pros and cons of traveling abroad under the current system, which has some sort of predictability with it on timelines, or wait indefinitely in the U.S. until this new provision is in place, if it ever is enacted. You still take the risk of being picked up at any time, being in the United States in unlawful status. There are pros to processing as usual, going to the consulate abroad to file the waiver. First of all, you have an idea of how long it could take. At the consulate, typical processing times are available, so you would have an idea of how long it would take for your case to be decided. There is no indication of how long the case will take to be decided once the proposal becomes effective. You also cannot be sure that the proposal will actually happen, given the current political climate. Another reason to continue filing your waiver under the current policy is that if some of your arguments will be unable to be documented in a year or more from now, when the proposed policy could become effective, it may be better to file now while you still have availability and stronger proof. Third, you don't want to wait anymore. You want the process over with. This is a very common reason, and I hear this from my clients all the time. The waiver process can be emotionally draining, and clients have often put their lives on hold, awaiting the outcome of whether they will be separated a long time from each other, depending on the outcome of the waiver. Fourth, there is no guidance on what happens if a waiver is denied in the U.S. under the provisional process. There is great concern that all denials will receive a notice to appear for immigration court, and applicants will be placed in removal proceedings. So what now? We expect more explanation on the new process once the rulemaking procedure ends for this provision, which could take months before this procedure is put in place and utilized, and assuming the provision becomes reality past the November 2012 election. Currently, CIS is expecting the final rule to be in place by the end of 2012. Call us today to book your free consultation with me to discuss whether you are eligible for a waiver and get an introduction to our in-depth waiver review process, so you really know your chances, so you don't waste time, money, or undue separation from your spouse on a weaker case. I am an expert in complex family-based immigration cases and have a 98% approval rate for the past 12 years. I am a nationally published immigration author and frequent public speaker on immigration topics. I regularly train other immigration lawyers on complicated marriage and family immigration cases for the American Immigration Lawyers Association, Federal Bar Association, and National Legal Education Providers. I represent clients all over the U.S., traveling to immigration interviews and deportation proceedings. Visit our website, humanrightsattorney.com, for more in-depth information and articles on complex family immigration issues.